This is Supreme Court citation of case Arnesh Kumar versus State of Bihar, and another happened in 2014. This case comes to the conclusion of Section 41A. It means Section 41A is amended due to this case by the Supreme Court in the interest of society and for avoiding unnecessary arrest of persons with very good character in the society. This case facts are mentioned here. Arnesh Kumar is the appellant and State of Bihar and another are respondents. Judgment passed is as Chandramouli K.R. Prasad, the petitioner, apprehends his arrest in a case under Section 498A of the Indian Penal Code 1860 and Section 4 of the Dowry Prohibition Act 1961. The maximum sentence provided under Section 498A IPC is imprisonment for a term which may extend to 3 years and fine, whereas the maximum sentence provided under Section 4 of the Dowry Prohibition Act is 2 years and with fine. Petitioner happens to be the husband of respondent number 2 Sweta Kiran. The marriage between them was solemnized on 1st July 2007. His attempt to secure anticipatory bail has failed and hence he has locked the door of this court by way of this special leave petition. Here, Sweta Kiran is respondent who is wife of petitioner. Petitioner appealed for special leave petition and leave is granted in this judgment. This judgment tells that our endeavor is in this judgment is to ensure that police officers do not arrest accused unnecessarily and magistrate do not authorize detention casually and mechanically. In order to ensure what we have observed above, we give the following directions as follows. The magistrate, while authorizing detention of the accused, shall peruse the report furnished by the police officer in terms aforesaid, and only after recording its satisfaction, the magistrate will authorize detention. The decision not to arrest an accused be forwarded to the magistrate within 2 weeks from the date of the institution of the case, with a copy to the magistrate, which may be extended by the superintendent of police of the district for the reasons to be recorded in writing. Notice of appearance in terms of Section 41A of CRPC be served on the accused within 2 weeks from the date of the institution of the case, which may be extended by the superintendent of police of sub-district for the reasons to be recorded in writing. Failure to comply with the directions aforesaid shall, apart from rendering the police officers concerned liable for departmental action, they shall also be liable to be punished for contempt of court to be instituted before High Court having territorial jurisdiction. Authorizing detention without recording reasons as aforesaid by the judicial magistrate concerned shall be liable for departmental action by the appropriate High Court. In this judgment, text explains us also that we hasten to add that the directions aforesaid shall not only apply to the cases under Section 498A of the IPC or Section 4 of the Dowry Prohibition Act, the case in hand, but also such cases where offense is punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years whether with or without fine. In this case, order dated 31st October 2013, this court had granted provisional bail to the appellant on certain conditions and made order absolute.